Facts of the case. The water that flows from the Danube River is responsible for providing clean water and transportation for millions of people in Hungary and Czechoslovakia. However, these waters have become subject to a fierce political battle that has left large portion of Danube River in Hungary's side dry and desolate. This problem stems from the treaty between Hungarian People's Republic and Czechoslovakia's Socialist Republic concerning the construction and operation of Gabčíkovo-Nagymaros system of locks. The parties, Czechoslovakia and Hungary, both entered into an international treaty in September 16, 1977 for the construction of network of dams at Gabčíkovo and Nagymaros for the production of electrical power, food control, and improvement of the navigation. The construction work started in 1978, with both sides contributing equally. Czechoslovakia would be responsible for building Gabčíkovo Dam and Hungary for Nagymaros Dam. In early 1980, public opposition began in Hungary owing to economic and environmental grounds. In 1983, construction of the dam slowed down because Hungary was facing severe economic downturn. Soon after, Hungary attempted to start working out on the dam again, but environmental activist groups staged a protest to prevent the construction as it adversely affects the water sources of Hungary, adding that the government is hiding the environmental consequences due to the construction of the project. In 1989, some 150,000 people had signed a petition opposing the project. Hungarian Prime Minister Miklos Nemeth suspended work due to public pressure and criticism. Czechoslovakian officials were disgruntled that Hungary stopped construction of the dam and argued that Hungary illegally broke their treaty. Soon after, in 1990, Czechoslovakia diverted the Danube River in what they call the Barents Sea as alternative solution, which will divert the river in their side 10 kilometers upstream. By diverting the river, Czechoslovakia could harness the same hydroelectrical power and navigative ability without Hungary's help. However, Hungarian politicians countered that they were justified in stopping the project due to its negative environmental impact. Due to Barents Sea, Hungary lost up to 90% of their water flow to the Danube. Authorities have recorded of more than 100 days of shallow water a year, which damaged the wild flora and left several hundred ships stranded along the river. In May 1992, Hungary decided to transmit a notification of termination of the 1977 treaty to Czechoslovakia, which was supposed to take effect in 6 days. In April 1993, Hungary and Czechoslovakia agreed to submit the dispute to the International Court of Justice.
Good day, everyone. I am Ruth Galaraga, and I'm going to tackle the issues that were brought before the International Court of Justice in this Gabčíkovo-Nagymaros project case. So in 1993, the two parties decided to bring the case to the International Court of Justice, and among those questions, these are the following that was raised or that were raised before the Court of Justice. So number one, was Hungary entitled to suspend and to subsequently abandon the works of the Nagymaros project. Number two, was Czechoslovakia entitled to conduct its unilateral activity on the Danube River? Number three, what were the legal effects of the notification of the termination of the treaty by Hungary? So, before proceeding, let us first define the terms. We have the state of necessity, which reflects an international customary rule, according to which a factual situation of a grave and imminent peril for the essential interests of the state would, which would legally justify a breach of international obligation by such state as the only means to safeguard such essential interests. So next, we have the doctrine of impossibility. Here, the doctrine of impossibility refers to situations when it is impossible for a party to a contract to perform. Next is the variancy. Here, the term variancy in this case, uh, it is the term used for the project that was called to for a plan by the Czechoslovakia in 1992, which worked to divert the Danube River into a power canal controlling 80 to 90% flow under an alternative project, and this is known as the variant scheme. So in this presentation, uh, we are going to discuss the contention of each parties that they use to defend before the Court of Justice. Here, first we're going to present the Hungary's contention. First, they contended they contended uh, in to defend their possession that the abandonment of the project was legitimate with these several reasons. First, the state of necessity, which Hungary was forced to act in a way that did not conform to their obligations to Czechoslovakia in order to protect the integrity of the Danube River. Second, we have the doctrine of impossibility. Here, Hungary used the doctrine of impossibility, stating that they may relieve themselves from the liability of the contract if the subject matter of the contract ceases to exist and essential person or object or person is deceased or the service or goods contracted has become illegal. So third, we have the fundamental changes in circumstances. Here, scientists on both sides had found that there is environmental damage and that here the river was far more worse than had been predicted. So here, Hungary argued that there were four events or series of events that together are cumulatively would constitute a fundamental change in circumstances, and that these are, uh, first of all, the profound changes of a political nature or the political atmosphere. Second, the diminishing viability of the project in terms of economic values. Third, that there was progress in environmental knowledge. And lastly, that there were developments in international environmental law or that development of new norms of international law. Fourth, in Hungary's contention here, Hungary contended that there is a material breach of the treaty. Czechoslovakia implemented an alternative solution to continue the project, to which Hungary claimed that this was a breach of the treaty. Here, Hungary argued or contended that Czechoslovakia had committed two material breaches. The first one was that Czechoslovakia refused to enter into negotiations with Hungary in order to adapt the project to meet new legal and scientific developments concerning the environment. Second is that Czechoslovakia had unilaterally put in place the Variance C, which also constituted a breach of the 1977 treaty. To continue, we now proceed to the Slovakia's contention. Here, Czechoslovakia approached the International Court of Justice to defend their position that there's uh, the alternative project. Here, in proposing their alternative solution by the name Variant C was a legitimate act. Next, we have the prevention. Here, Hungary's suspension of the treaty prevented Czechoslovakia from carrying out their responsibilities. Next, third, the duty to mitigate damage. Here, Slovakia was acting under a duty to mitigate damages imposing the variant fee or the plan to divert the Danube River. So that's all for the issues and the parties' contention, which were brought to the ICJ for a decision. So now we proceed to the ruling, which shall be discussed by my colleague. Thank you very much.
There were three issues that was raised before the court. The first issue, whether or not was Hungary is entitled to suspend and subsequently abandon in 1989 the works on the Nagymaros project. Second issue, was Czechoslovakia entitled to conduct its unilateral activity on the Danube River? And third issue, what were the legal effects of the notification on May 19, 1992 of the termination of the treaty by Hungary? So the court answered all these questions by first looking at the 1977 treaty itself. And they have found out that the 1977 treaty did not provide for termination. There is no provision for termination, enunciation, or withdrawal. So, what does this mean? Can a party terminate a treaty in the absence of a provision to that effect? Or a party like Hungary or Czechoslovakia can unilaterally terminate the treaty? So the court answered this by looking at the intention of the parties and the nature of the treaty. And even if the court did not say it, it's actually a no. As reflected in Article 56 of the Vienna Convention on the Law on Treaties, this article says that if a treaty is silent, that it cannot be terminated unless it cannot be terminated unless the parties intended to do it or the nature of the treaty allows for it. So the court looked at these factors and it found out that there was no evidence to show that the 1977 treaty intended it to be terminated, nor the nature of the 1977 treaty warrant a conclusion that this could be terminated. So in this case, the International Court of Justice concluded that if a treaty is silent on the issue of termination, then it could only be terminated on the limited grounds enumerated in the Vienna Convention. The court found out that the provision on termination under the Vienna Convention reflect customarily in international law. So, what were the grounds that Hungary provided in order to terminate the treaty in the 1997 treaty? So they have five. First is the existence of a state necessity. Second, the impossibility of performance of the treaty. Third, the occurrence of a fundamental change of circumstance. Fourth, the material breach of the treaty by Czechoslovakia. And fifth, the development of new norms of environmental law. If you have read the Vienna Convention, you will see that only argument 2, 3, and 4 find their basis in the Vienna Convention. So you can see that the argument 2, the impossibility of performance of the treaty, was anchored in Article 61 of the Vienna Convention on Law on Treaties. Argument 3, the occurrence of a fundamental change of circumstance, was based in Article 62. And argument 4, the material breach of the treaty by Czechoslovakia, is based on Article 60. Now, let's take a closer look in argument 2. The impossibility of performance, which is the basis, is the Article 61 of the Vienna Convention. Article 61 allows for a termination of a treaty in case of a permanent disappearance or destruction of an object indispensable for the execution of the treaty. So in this case, What was the essential object in the view of Hungary? Well, according to Hungary, the essential object of this treaty was the economic joint investment consistent with the environmental protection operated by the two contracting parties jointly. So this object was not a tangible object. It is not an island or an object capable of destruction. It is actually a legal regime. Although the court did not comment that this object could actually be intangible like a legal regime, the court immediately rejected the argument for two reasons. So the first reason is the treaty itself has provisions for adjustment, and second, the impossibility here is due to Hungary's failure to fulfill their obligations in the treaty. So Article 61, Paragraph 2 of the Vienna Convention states that a party cannot terminate the treaty based on one party's failure to fulfill the obligation. Hence, in this argument, Hungary failed to prove it. Therefore, it is rejected by the International Court of Justice. Now, let's go to argument 3. Hungary based this one on the Article 62 of the Vienna Convention. Article 62 allows the termination of the treaty when there is a fundamental change of circumstance. But this is subject to very strict requirements. As you can see in subparagraph A and B, so what were the arguments of Hungary? According to Hungary, there were 4 events that cumulatively happened, creating a fundamental change, and there are the following. First, the profound changes of political nature. Second, the diminishing viability of the project in terms of economic value. Third, that there was a progress in environmental knowledge. And fourth, that there were development in international environmental law. So what was the court response? The court's response was that the profound changes of the political nature and the diminishing viability of project in terms of economic value was not closely tied to the project and the object of the treaty. Therefore, it does not form any essential basis of the consent. So subparagraph A of the Article 62 was not satisfied and cannot apply. Nor do they radically alter the extent of obligations still to be performed. So also subparagraph B is still not satisfied. And in the arguments about environmental knowledge and international environmental law, the court held that these changes was not unforeseen, and to see is one of the requirements under the Article 61 of the Vienna Convention. And then finally, we have the argument 4, which finds its basis on Article 60 of the Vienna Convention. In this article, it allows for the termination of the bilateral treaty or the suspension depending on the circumstance if one party has committed a material breach. So according to Hungary, Czechoslovakia committed 2 material breaches in the treaty. First, that Czechoslovakia refused to enter into negotiations with Hungary in order to adapt the joint project to meet new developments concerning the environment, and that second, that Czechoslovakia unilaterally put in place Variant C. So the court held that there was no sufficient evidence that Czechoslovakia has refused to enter into negotiations with Hungary, and that when Hungary transmitted its notification of termination in May 1992, Czechoslovakia had not violated any international law or provision of the treaty in placing Variant C. Hence, the court held that Czechoslovakia did not commit any material breach during the notification of termination on May 1992.
Issue: was Czechoslovakia entitled to conduct its unilateral activity on Danube River? The International Court of Justice held in the negative and ruled that While Hungary was not right in suspending or abandoning the responsibilities in the treaty, neither is Czechoslovakia right in imposing the variancy alternative solution. What is the legal basis of the ruling? The legal basis of the ruling is the doctrine of pacta sunt servanda, which states that what has been agreed to must be respected, as the duty to perform one's obligations is not something unique to international law and the law of treaties. A similar principle can be found under the law of contract of many domestic legal traditions throughout the globe. Every agreement of a legal nature, whether it's a contract between individuals or a treaty between states, presupposes that in concluding the agreement of the parties acted with the intention to abide by its provisions. What was originally an uncodified rule based on customary practice now is codified under the Vienna Convention on the Law of the Treaties. The principle of free consent and of good faith and the pacta sunt servanda rule are universally recognized. Every treaty in force is binding upon the parties to it and must be performed in good faith.
So to answer whether there was legal, whether there were any legal effects of the notification of the termination of the treaty by Hungary, in this case, there was none. Here, the court first argued that there was no evidence or not sufficient evidence to show that the Czechoslovakia had refused to enter into negotiations with Hungary, and that when Hungary transmitted its notification of termination in May 1992, Czechoslovakia had not violated international law or any international law or a treaty by putting in place the variant C. So, in the court's view, Czechoslovakia at the time of the notification of the termination in May 1992 had not committed any material breach, and therefore, again, it rejected Hungary's arguments. So, here, also, the court also drew attention to the procedural issues concerning the termination, and the court said that even if one state is allowed to terminate treaty, there are procedural requirements that need to be met, and these procedural requirements are found in the Article 65 to 67 of the Vienna Convention, reflecting customary international law. Among which, for example, is the Article 65, which states that termination can only take effect only after 3 months after the receipt of notification for the termination to take effect. Here, Hungary wanted to terminate the 1977 or the treaty within 5 days, and this was of course not reasonable and did not meet the requirements of Article 65 of the Vienna Convention. Therefore, the court concluded that Hungary's termination was premature. So, in conclusion, with all the given reasons in this, with as regards to the issue, the court rejected Hungary's argument, and it found that the notification of termination that Hungary transmitted did not have any legal effect. So that's all for in answering as to whether or not there was any legal effect in the notification of the termination by the Hungary. To repeat, there was none.
So, what are the important takeaways from this case in relation with public international law? So, the first lesson we can get is that the international law Court of Justice has the jurisdiction to hear cases involving the environment. And second, for a treaty partner to claim that there was a fundamental change in the circumstances that prevented them from completing their portion of the treaty, the changes must have been unforeseen. And lastly, lesson 3, we have learned here the concept of pacta sunt servanda, meaning what has been agreed to. So what are the important takeaways from this case in relation with public international law? So first, we have learned that the International Court of Justice has the jurisdiction to hear cases involving the environment. The second lesson is that for a treaty partner to claim that there was fundamental change in circumstances that prevented them from completing their portion of the treaty, the changes must have been unforeseen. And third, we have learned here the concept of pacta sunt servanda, meaning what has been agreed to must be respected. It is necessary for states to bound by the commitments they undertake. Hence, in this case, the 1977 treaty was still in force and primarily ruled the relationship between Hungary and Slovakia. That's all. Thank you.